This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk a little bit about criminal law because fraudsters often go to jail. And this time we must understand that it takes evidence to withdraw a guilty plea and that a fraudster has no basis to withdraw his guilty plea by merely blaming his lawyer for a guilty plea that needs admissible evidence when the lawyer gave him good and legal advice, and why a judge will refuse a request to withdraw a plea because blaming your lawyer for a guilty plea needs admissible evidence. In United States of America v. Glenn Griffin, the United States District Court for the Southern District of New York, on March 13, 2025, dealt with the fact that Glenn Griffin sought to withdraw the guilty plea he entered on August 26, 2024. During a change of plea hearing before Magistrate Judge Victoria Reznik, Griffin pleaded guilty to one count of conspiracy to commit bribery and one count of conspiracy to commit wire fraud that he wishes to change when he found out what his sentence could be. Glenn Griffin made two key arguments in his motion to withdraw his plea. One, improper pressure from counsel. Griffin argued that his plea was not knowing and voluntary because his prior counsel, Stephen J. McCarthy, Jr., improperly pressured him to plead guilty. And two, there were intervening developments. Griffin maintained that intervening developments since the plea hearing revealed the government's case to be substantially weaker than he was initially led to believe by McCarthy. Now, this started because Griffin was arrested on July 21, 2022 on an indictment that included charges of bribery and wire fraud, among others. He was accused of conspiring with Robert Dickman, an employee of the town of Cortland, New York, to allow unauthorized dumping at a town facility in exchange for bribes. Additionally, Griffin was involved in a bid rigging scheme to defraud many municipalities. At the time he was offered a plea, there was a colloquy between Mr. Griffin and Ms. Reznik. The colloquy turned on when the magistrate judge asked Griffin to say in his own words, quote, "what you did to commit these crimes," period, close quote. Griffin responded by partially admitting to some of the charged conduct. He acknowledged that he gave Bobby Dickman a couple $100 a few times around the holidays as a gratuity, close quote. And he also said that, quote, "as far as bids, I did ask people over time to help me just because I had a relationship with people. And I did ask other people to put in some bids," but asserted that, quote, "he didn't do it with all the ones that they said," close quote. When Judge Reznik asked if Griffin had agreed to an illegal dumping scheme, he responded, "no." But later, quote, "in for just to make this easier on everybody, yes, Your Honor, but it was a few $100 a couple times, and I had permission for years and years and years," close quote. Griffin's sworn testimony during the plea colloquy carried a strong presumption of accuracy, and that his later contradictory statements were found by the court to not be sufficient grounds to withdraw the plea. The court also found that Griffin's counsel had provided an honest assessment of the case and that Griffin had ample opportunity to discuss the plea agreement with his counsel. The voluntariness of Griffin's guilty plea was the dispositive issue presented to the district court, and the court concluded that Griffin voluntarily pleaded guilty. When a court rejects a defendant's claim of involuntariness, that finding alone is sufficient to reject the defendant's motion to withdraw his guilty plea. Griffin testified that on August 26, Mr. McCarthy encouraged him to plead guilty, but made clear that the choice was Griffin's alone. Not only did Griffin's testimony undermine his claim that Mr. McCarthy coerced him to plead guilty, but it reinforced the presumption of verity attached to the statements he made during the plea colloquy. Griffin failed to meet his burden, and Griffin's motion to withdraw his guilty plea was denied. Griffin's sentencing will proceed on April 22, 2025 at 10 a.m. In my opinion, plea bargains exist to save the time of the prosecution and the court when the defendant agrees that the facts against him are sufficient to find him guilty by a jury, and when a lesser sentence that he would have received if found guilty by the jury. Second thoughts about his guilt are insufficient to allow a person who voluntarily pleaded guilty to withdraw his plea. And so he will be sentenced in April, and he will spend time in the Gray Bar Hotel. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe at that page, and when you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and videos. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.